All rise. The Honorable Court of Appeals for the 7th District of Texas is now in session.
Please be seated. And there you go. You got to turn on the machine. We welcome you to the November 1st, 2023 settings of the 7th Court of Appeals, sitting in Amarillo. November 1st, I don't know where the year's going. Everything's flying by, amazingly. But we have two cases for this morning. We'll call the docket for the first case. And I know the attorneys in the second case are here, but we'll just call the docket for the first case and get their announcements. Then we'll take a brief recess to change panels. And then Justice Parker will be heading up to second, and she can call the docket then. For the second case, we do appreciate the attorneys venturing to Lubbock, especially those in the first case, and surviving Halloween night in order to present their best form this morning. Maybe you have some of that candy left or the sugar rush to get you through the morning. The first case we have for this morning is a combination of three action. 07-22-00303-CR, 07-22-00304-CR, 07-22-00305-CR, Tory Lane Henderson versus State of Texas, Amada Ridge versus State of Texas, and Justin Royce Thompson versus the State of Texas. And we have a few attorneys here this morning representing the appellants and arguing for the appellants. It is
Savannah Kumar, Your Honor, for the appellants.
Thank you very much. And you will be doing the entirety of the argument?
Yes, Your Honor.
Very good. And for the appellee?
Yes, sir. Darren Keith, Orsburn, Assistant County Attorney representing the state, Assistant County Attorney for Cook County.
Thank you very much. As you can sit down, sir. As you've informed, there's 20 minutes per side for oral argument, and the appellants automatically have an additional 5 minutes, so you don't have to ask for an additional time. You get that. We don't necessarily allow carryover of extra time from your initial argument to your rebuttal, so if that becomes an issue, request, and we'll see what we do. As I said earlier, we tend to ask questions. We appreciate prompt answer to the questions, and if it requires exposition, give us the answer, and then you can expand on it a little bit, and we'll go from there. Sometimes we play devil's advocate. It does not necessarily indicate how we're going to rule, but we do that in order to kind of flesh out issues that we may have in our mind. With that said, Ms. Kumar. Mr. Ramirez, would you mind closing that door behind me, please?
Good morning, and may it please the court. Savannah Kumar on behalf of appellants Tory Henderson, Amara Ridge, and Justin Thompson, two of whom were able to travel with me to be here today. Appellants were charged with and convicted of violating Section 42.03A1 of the obstruction statute under a sweeping interpretation of the statute that deviates from the Court of Criminal Appeals' binding precedent and fails to allow for the requisite breathing room under the First Amendment. No Texas court has upheld a violation of the obstruction statute under similar circumstances. I will be focusing my time in oral argument on the insufficiency of the evidence to show that, one, appellants actually obstructed a passageway, and 2, that they had the requisite mens rea of knowledge and intentionally obstructing it. However, I would like to also just briefly note for the court that among the 11 points of error on appeal, there are 2 jury charge errors, errors 7 and 9, that were objected to at trial and preserved, and so they require just some harm for reversal. So turning to the insufficiency of the evidence, there is no particularized evidence to show that the actions of Ms. Henderson, Ms. Ridge, and Mr. Thompson actually caused the result of obstructing any passageway.
Counsel, if I may interrupt, the briefs referred to, especially the state's brief, referred to a video. Is it a video of the entire event, or is it portions of the event?
Your Honor, there were a number of videos. I believe that the video that is cited by the state's brief is a video of a portion of the march that occurred.
Does the record contain enough videos, different videos, to depict the entire march, or not?
There are videos that depict the march and events that also occurred before it as well. However, not all of it was shown, I believe, to the jury.
Okay. And those videos should show the placement of the protesters, so to speak?
So one of the issues with the video is that the videos don't necessarily capture each of the appellants and their particular position within the march. And that's one of the core issues in this case, is that while the state points to general evidence about marchers and the march, it fails to provide particularized evidence to show that each of the appellants had the requisite elements under the obstruction statute to sustain a conviction, and that's something that's a problem with the video as well. However, to answer your question, in terms of the march overall, there are, the video does capture at least some parts or some people who are part of this march at various points of it.
Would you agree that in that video, the other people were obstructing a passageway?
Your Honor, first, again, this is a question representing the appellants in this case. I can speak specifically to their actions in the march and their mens rea, the lack of mens rea as it applies to them. But when we're speaking about actual obstruction, even the video of the march as a whole does not show obstruction. And part of the reason for that is because the court in Sherman v. State, which is a court of criminal appeals case, found that it was not obstruction when a picketer was crossing, even at snail's pace, slowing down his pace to half steps when he noticed that a car was approaching.
Has the Court of Criminal Appeals addressed a case where they said there is obstruction, what was happening is obstruction?
Yeah, yes, Your Honor. There are cases that have found that there has been obstruction. For example, there's Hay v. State, and that is a Court of Criminal Appeals case. And the critical difference between that case and the case here is that in that case, the appellant was not moving at all. The person was actually stationary and blocking passageway. And that's one of the core distinctions when we see that the court in Sherman v. State found that when the picketer, it was a picketer in that case, was moving continuously, even at snail's pace, which isn't part of the evidence here. There's no evidence that appellants slowed down at all. They were moving continuously, and there's
does the statute address movement?
The interpretation of the statute by the court in Sherman v. State, the Court of Criminal Appeals, as well as the Fifth Circuit in evaluating Court of Criminal Appeals decisions, has found that there must be, it has only found that there's obstruction in the case of not having movement. However,
the Sherman case you cited involved a picket line, which was a very small space and a designated space. This march occurred over several city blocks and involved a state highway. Isn't it distinguishable on those facts?
Your Honor, the issue here, in fact, the state points to about 3 distinct places, 3 different distinct moments where there may have been an obstruction. And when we look at each of those moments, we see that 2 of them occurred just in crossing a street, and that is all that appellants did. They crossed the street once in order to get to the other side of the street, which is very similar to the issue in Sherman. But then even when marchers were marching continuously along the passageway, the critical difference there is that there is no evidence to show that there are any cars that were behind them and trying to get past them at those moments. And
Well, the crossing here that you mentioned involved 30 to 40 people, which did stop traffic, and one of the vehicles, the driver of the vehicle, actually testified to being stopped. True?
Your Honor, it is true that there was a driver, Miss Idem, who was stopped, testified to being stopped, and that stop was for seconds that she was stopped for. And in fact, the evidence in the record is clear, with no evidence to the contrary, that the reason that she was stopped was because of people who were not appellants themselves, who had stopped the driver.
You're referring to the bicyclist and the person that was carrying the long gun.
Exactly, Your Honor.
But in order for the other people to safely cross the street, do you acknowledge that there is evidence in the record that the remaining people did cross the street at that point?
There is evidence in the record to show that there was a crossing by marchers at that point, when there was, as Your Honor, you mentioned, the bicyclist in the street at that time. However, Captain Gardner explicitly testified that it is legal to cross at the place that appellants crossed. Again, this is referring to the first incident, or the first moment of obstruction that the state points to. And Captain Gardner testified that it's legal to cross there, just not to stop traffic there. And explicitly testified that Miss Ridge, Miss Henderson, and Mr. Thompson did not stop that traffic. And furthermore, the state did not bring a theory under the law of parties in terms of the appellants. The jury charge contained no instructions about the law of parties. And so even if they were crossing the street, again, the video in fact shows that this crossing was no longer than about 30 seconds. And the case in Sherman v. State shows that the person was moving at snail's pace, in fact, slowing down his steps when he saw a car approaching to become half steps.
Does the penal code or the Sherman case define the word obstruct?
The penal code defines the word obstruct in 42.03b, and the definition is to render impassable or to render passage unreasonably inconvenient or hazardous. And we see that that language has been interpreted. Sherman says that obstruction means that a passageway must be severely restricted or completely blocked. And in Hardy v. State, the Court of Criminal Appeals makes clear that section 42.03a1, which is the only part of the obstruction statute that appellants here were charged with and convicted under, requires actual obstruction rather than potential obstruction. And so because of that, and in Hardy, the court there found that where people were standing in a road at a time when no cars were passing, that does not constitute obstruction. And so, Your Honor, when we see the other moments of incidences that the state points to, for example, when marchers, again, not specifying appellants themselves, but marchers were walking through the street on the way back to the courthouse, there's no evidence in the record that there were actually cars that were behind them. And
does the statute, though, as I'm looking at it, contemplate that the defendant can be convicted even though the obstruction is being caused by somebody else?
No, Your Honor. So the text of the statute is clear that if the obstruction arises from his acts alone or from his acts and the acts of others, and so it still requires a person's acts to be a part of the obstruction.
Does that mean that that person has to obstruct, or can that person be engaged in conduct with others, and others do the actual obstruction, but they're working together?
So first, here, there's actually no evidence either that appellants participated in the obstruction or that they instructed anyone to obstruct at all. And we have clear testimony from Appellant Thompson, who repeatedly told people before and during the march to stay on the sidewalks and to trying to have a peaceful march that day. And so, first of all, neither of those things are shown here. However, there would have to be a closer nexus to answer your question between appellants and the actual obstruction, not just holding appellants accountable for others' actions. And such a reading of the statute that would hold appellants criminally liable for the acts of others that are unrelated to them, who they don't even know who they are, would be an overbroad reading of the statute that would make it would severely chill the free speech rights of Texans, because it would mean that an organizer of a march could be held criminally liable even if they are telling people, giving people clear instructions, for example, to stay on the sidewalks, and then other people get into the streets at moments, if that's the reading of this case, of the statute in overbroad way. But there's also mens rea.
And the mens rea, intentionally and knowing. Definition of knowing?
Yes, Your Honor. So the definition of knowing that was in the jury charge, and there are actually some jury charge errors here as well. And so I'll read to you from what the definition of knowing was. So a person acts knowingly or with knowledge with respect to and the jury charge says with respect to the nature of their conduct or circumstances surrounding their conduct, when they are aware of the nature of their conduct or the circumstances exist, which appellants note is an error with the jury charge because obstruction is a results-oriented offense. And then the second part of that says a person acts knowingly or with knowledge with respect to a result of their conduct when they are aware that their conduct is reasonably certain to cause the result.
Is it conceivable that your clients, in being involved in this protest, knew that maybe others would not follow their instructions and actually stand in front of a vehicle with a long rifle or with a bicycle or in some other way to satisfy knowing?
Your Honor, no. There's no evidence in the record at all that appellants would have any reason to know that others would carry out these actions, which again, even those actions would not rise to obstruction under the interpretation in Sherman v. State. But there is no evidence in the record that would show that they knew this, and any sort of inference about that would really require stacking inference upon inference based on facts that are not in the record at all. And so no, the answer to that is no, they didn't. They wouldn't have known this. And in fact, they instructed the opposite, or at least one appellant who is speaking for the group instructed the exact opposite of that. And so with no evidence...
Was that instruction caught on video?
To stay off the street, there's some voice that I believe is heard in the video around staying on the sidewalk, but I could not tell you at this time if the audio in the video is tied to a appellant, but I can say that at least in the record before the jury at the trial court level, it's clear that those instructions were given, and it's not contested that those instructions were given.
And what about the evidence where the officers verbally instructed the marchers to get out of the roadway, but they refused? Wouldn't that be evidence that would go to intent?
So, Your Honor, first looking at that particular instruction, that would have occurred at about moment 2, which is when marchers were crossing back to the courthouse. And so at this point, it's around this point where there was an explicit instruction by the Gainesville Police Department that appellants or marchers in general were allowed to be on the street to avoid a water hazard that was there. And so it would not show mens rea necessarily for people to have stayed in the roadway, but I would also note for this court that appellants were not charged here under section 42.03A2, which is a separate part of the obstruction statute, and that is the part of the statute that involves disobeying a reasonable request or order to move issued by a person.
Even though that was included in the jury instruction.
Yes, Your Honor, and that's another error that appellants bring, is that that language was included in the first paragraph of the jury instructions.
Before we go to the jury charge there, staying on Justice Parker's mens rea issue, the chant itself, whose street, our streets, is that not some evidence the jury could determine mens rea?
in terms of mens rea for the appellants, the record is not, it does not show that the one person who was, one appellant who was tied in any way to that march, which is appellant Henderson, actually started that march. In fact, it just shows that that chant was started at around the time that there was an instruction to move, and so it cannot go to the mens rea of that.
Does it show that any of the appellants were involved in that chant?
No, Your Honor.
Does it show that any of them uttered that chant?
There's no evidence in the record that they necessarily uttered that chant, but that I am aware of right
If
now.
you could utter that chant while you're standing in the curb walking on the street and cars can pass by, is that evidence of obstruction?
If cars can pass by, no, Your Honor. Again,
So we have the one instance where a car was stopped by somebody with a long gun and a bicycle. And how long were they stopped?
if the, it would be seconds. The driver who was stopped testified was between 20 seconds and 90 seconds.
Does that make a difference, being stopped 20 seconds versus a minute and a half?
Your Honor, under Sherman v. State, it would still be much closer to something like a momentary stop. That would have been the case in
Let
Sherman.
me ask you with regard to the definition of instruction. They're talking about render impassable or render passage unreasonably inconvenient or hazardous. Does unreasonably modify both inconvenient and hazardous, or are those two different things, but in your view?
Your Honor, the question of whether reasonableness,
And where I'm going is, do the circumstances dictate reasonableness? What would be unreasonable in a particular circumstance? So different circumstances may make something unreasonable or make it reasonable.
so to the first part of your question of which of the words it modifies, I will note that here there's no evidence in the record that appellants made California Street or anything else hazardous at all, and so the hazardous part of that statute isn't at issue here. The overwhelming evidence in the record notes that the march was safe. There were no incidents that actually occurred in terms of safety.
Well, does the hazards have to occur, or just that the circumstances would be hazardous?
So the court in Hardy v. State, again, gives guidance on this issue, and this is the Court of Criminal Appeals, that instructs that there must be an actual obstruction rather than a potential obstruction. And in fact, that's how it distinguishes between the two parts of the statute.
So you're saying that the marchers marching 5 across on a state highway, which I believe the record shows that was the highway that emergency vehicles used, and that the officers weren't prepared for a march occurring on a highway when everyone thought it was going to be occurring on a sidewalk, that wouldn't be hazardous or obstructing a passageway?
There's no evidence in the record that a car was behind appellants at that time, and that if there was a car, that appellants did not move out of the way. And so that is the issue here when it comes to that question. But in addition, we have testimony in the record from Captain Gardner that says, where he testified that we were ready for it, we were ready for them to march.
March down the sidewalk, not a highway, because they didn't get a permit, right?
It is true, Your Honor, that they did not get a permit in order to march, but the First Amendment does not require that there be a permit in order to walk along a public passageway.
Is it some evidence of mens rea that there wasn't a permit?
No, Your Honor, it would not be evidence of mens rea. The question of the permit is entirely separate from the question of whether there was an obstruction or not, and the lack of a permit does not indicate mens rea to actually block a car from passing.
I'm going to ask you during your rebuttal whether or not the concept of unreasonably inconvenient would encompass a circumstance where somebody is invoking First Amendment rights, as opposed to just somebody going down the street and decides to stop and stand in the street. So think about that, please.
Your Honor, I'm ready.
Whenever you're ready, counsel. Clock started.
May it please the court. Counsel for appellant. Law is order and liberty, and without order, liberty
But
is social
isn't it
chaos.
true that the law, order, and liberty on which the United States is based has arisen out of protest?
At times it has.
And a protest causes disruption?
A protest can or cannot. A protest might not cause disruption if done within the bounds of the law.
Whether or not it causes, depending on the circumstance, can the factor, as I asked opposing counsel to think, the factor that they are exercising a First Amendment right. Now, do you agree or disagree that they were not attempting to exercise First Amendment right?
I agree that they were participating in a political protest and that a potential defense of privilege did exist and was explained to the jury.
So,
And they
you would
elected
agree
not
that-
to go that route.
You would agree that they were attempting to exercise First Amendment rights?
They were attempting to participate in a political protest.
First Amendment, or are we not going to even agree there?
Sir?
First Amendment, or are we not even going to agree there?
Well, yes, it involved
Okay.
First Amendment.
Does the reasonable circumstances involving whether or not there is an obstruction contemplate a difference between circumstances where there's no attempt to exercise constitutional rights versus circumstances where there are attempts to exercise constitutional rights? Or is it a black letter, it's an obstruction, it doesn't matter the purpose of it? If they block anything, it's wrong.
Well, first of all, there's typically a balancing act in these cases,
Okay.
okay? And so just as one cannot falsely yell fire in a crowded theater and claim King's X, First Amendment, I have a right to say this. So a balancing act has to be applied to all these cases. Now, if
Are you indicating that what was happening here was comparable to yelling fire in a crowded theater
No.
with the limited exits and things?
No, I'm not saying that, but I am saying that, in essence, and that's what the Louderback case says, I believe. You cannot use the First Amendment as a King's X,
Okay.
all right? But if, I believe the Louderback case says that if you are being unreasonably restricted by a law enforcement officer, then that is a potential defense. So, the evidence here, justices, we had State's Exhibit 1, which was a video, and
Could a
this,
legitimate exercise of the First Amendment cause obstruction?
sir,
Could a legitimate exercise of the First Amendment ever cause obstruction?
it potentially could, and that would be, I believe, a question of fact for the fact finder whether it did or not. And I believe that's what happened here, or could happen here, or did happen.
Or would the trial court or would the court itself have to determine whether or not a fact finder could reasonably deduce that that was an obstruction?
I think the court would have to find and determine whether there was any evidence that suggested that, just as any other, like a suppression issue. If a court heard evidence of a suppression issue and the defense wanted a suppression issue in the charge, the court would have to determine whether or not there was any evidence. And it is a low burden, and it should be there.
But in the suppression issue, the test is reasonable, has factors of reasonable suspicion, for instance.
Correct?
Reasonableness is actually a legal question, though, isn't it, for the court to determine? Whether or not that those circumstances arise to what would reasonable suspicion be?
I believe it would be for the court to determine initially on whether or not to submit that question for a final decision to a jury. So, this did involve the pro-Gainesville organization, and these appellants were identified during the trial as leaders of the pro-Gainesville this pro-Gainesville organization that occurred, this protest event on 8/30/22 at the courthouse area in Gainesville. And they did conduct an unauthorized march. California Street, Highway 51 was obstructed 3 times.
I know you say they were identified as the leaders. Was there evidence in the record that they were identified as being part of the obstruction of the street?
Yes, sir, I believe that officers testified to that, and that's part of the record. And if I may refer, this is a duplicate of State's Exhibit number 3, and this is involving the second obstruction. The so-called water in the street happened down this way. And right here you see appellant, this is, I believe, appellant, not Henderson, but one of the appellants. This is appellant. These are the 2 female appellants in the case. You see her on a megaphone, and you see the other appellant handing, you see her holding the megaphone. And so officers, I believe, during the course of the trial, identified them as participating in the march. Appellant Thompson was in the back towards this direction. But here you see the long-armed rifle person that was involved in the initial obstruction when the bicyclist came out and stopped traffic with this long-armed person right there. We also have where
Stop traffic, were other people involved in the gathering of the protest passing behind him, crossing the road, or was he alone when he stopped traffic?
Are you talking about the bicyclist?
Either one.
Okay, well,
Both.
the bicyclist stopped
Right.
Miss Idle, and Miss Idle testified that not only did she have to stop, she had to stop abruptly
I understand.
to prevent harming.
I understand she was stopped, and then somebody with a long rifle also stood in front of her or something like that. Were the protesters walking behind them in an effort to cross the street, or did those 2 individuals just enter the street and stop people?
They were doing this continuous movement that they rely now on as a defense. And yes, there was continuous movement earlier when they crossed the street. But continuous movement is not a defense to an obstruction. You can have continuous movement and create an obstruction. That's what happened here. When the bicyclist had stopped with the rifle person right beside him, they continuously moved to the other side and continued their march back to the courthouse.
When
So
the group
continuous
passed by, did the person with the long rifle and the bicycle move, or did they stay there stopped?
I'm not sure. I believe the video might show that. Okay, and the video gives a complete picture of this march. You will hear, as far as mens rea goes, they claim that they had an incentive to obey the law because of their families and jobs. But again, we had this "Whose streets? Our streets" chant that in this group that they were walking and participating in, and they were. The record will show whether or not they were identified. I believe they were. And that you will see that one of the appellants, this appellant here, Miss Henderson, I'm going to get their names mixed up, so I'm going to one of the female participants, this lady, one of these 2, the record shows it, when confronted by an officer to get out of the street, all right, she shook her head no. She said, "No, we're not getting out of the streets." Now, they seem to be saying that because, this officer, whether or not officers were ordering, we didn't charge them with that, but it does still
Why
go
did you
to.
include that
But-
in the instructions?
Excuse me?
Why did you include that in the instruction then?
In the charge?
Yeah, it's your instruction.
Okay. Well, can I answer? Well,
Just don't forget my question.
Yes, sir. All I wanted to say was, What was I talking about?
I guess you're talking mens rea with regard to
Oh.
them saying, no, we're not going to be leaving.
Yes.
We're not gonna-"
Yes, and there was clearly officers instructed them, and they were and she said no. She shook her head no. And furthermore, there was in the video, you will hear the video person that took this video, who was participating in this march, you will hear him make the comment, they're telling us to get out of the streets, and we're not doing it. And where I wanted to go with that is that we're not using that for the second prong of obstructing. We're using that to show they knew what they were doing. They knew that they were in the streets. And if you look at
And
this,
the comments, we're not doing that, can be heard on the video?
yes, sir, by the person that took the video himself.
Go, forget my other question.
Okay, in regard to the charge, and what was your question about?
It was about the instruction disobeying a reasonable request or order to move.
If you're not charging them with that, why'd you put it in the charge?
Because we felt like that went to the defense privilege. In other words, we felt like that there is a privilege here, and the defensive privilege would be that that if it was an unreasonable order, then they had a defense of not obeying.
If it was unreasonable for them at that time to be in the street,
If they were receiving unreasonable orders or unclear orders, then that would potentially be a defense if they would
Wouldn't that
exercise
defense
First Amendment.
be a defense to a charge that you're ignoring orders?
I'm sorry?
Wouldn't that defense, as you described it, be a defense to a charge that you were ignoring the orders, as opposed to a charge that you're causing an obstruction?
It would be a defense that they were exercising the privilege. If they were receiving,
Vis-a-vis obstruction,
right?
but why did you include the other thing, the other charge?
Well, what part of the charge are you referring to?
You didn't order, reference to you didn't obey a police directive. But that was not objected to, correct?
I don't believe so. I don't.
We'll switch track.
well, wait, before we go on something else, what about the, you're talking about the privilege, accompanying the marchers along the protest route? Isn't that tantamount to legal privilege and authority?
Are you talking about the theory that they were escorted by police?
Yes.
Okay. First of all, I would ask you to look at this video, or the picture here. You don't see any police at all escorting.
No, but the video shows at several different portions, and I believe the testimony was that there was at least 3 officers at different points. Some were at the back, or one was at the back, and I think 1 or 2 maybe along the side of the divided, the no passing stripes in the street.
Okay? There was testimony that officers at that point were trying to escort them to get them out of the streets at some point.
After the water,
And this was after the crossover obstruction, and then they come up the street, they come to the post office where there was a puddle of water. At that point, they did allow them to get back, and then they said, or allow them to get off the sidewalks to miss the water. Then they were told to get back on the sidewalks. That's when one of the appellants shook her head, no, we're not doing it. And then that's when they all got into the street right here. They're going down West California, then they get up to the courthouse and they take a diagonal right across the street, and they block all the streets. That is the third obstruction.
so which obstruction did the jury decide on? Was it the first one, the second one, or the third one?
There were no specific acts because it was not pled disjunctively. It was pled globally or as an obstruction.
And that's one of the points on appeal for appellants, is
That is one of the points on appeal, and our position on that is that this was not our pleading, and there was never a motion to quash our pleading. There was no objection at the charge conference on this, okay? There was no requested instruction, but even as it is, this is not, our pleading is not disjunctive. Our pleading is that they obstructed it by creating an obstacle by stopping traffic. The number one, we don't allege the number two way to do this. It would be like in a DWI case where you allege per se and you allege normal loss of use in your complaint and information. At charge time, you would have to have a disjunctive charge. But because this is not a disjunctive pleading, there is no requirement for a disjunctive charge and a unanimous verdict on each specific act as they request. I know I'm running out of time.
Counsel, if you're looking at that picture, given the number of people involved, given the size of the signs and such like that, could they have done the same thing on the sidewalk? I don't know how big those sidewalks are there. Sometimes they're big, sometimes they're not in these smaller areas, but could they have done their movements on the sidewalk without obstructing?
Yes, sir, and they did initially. And there was testimony.
Was there evidence that people were on the sidewalk?
Yes.
They had to stop in order to allow these people to do what they were doing?
No, but there was testimony that initially, and Appellant Thompson warned them. He said, be careful. They're going to try to arrest you. Be careful that you don't get into the streets. But eventually they did. And particularly after law enforcement stopped following them, and that's what happened. Law enforcement stopped following them. They crossed the railroad tracks, went down a bit, and that's when they made that first obstruction. Now, I would like to...
During the first portion of the march going east, I guess,
Yes.
everybody was on the sidewalk. It wasn't until after they crossed the street.
Pretty much. Sometimes they would get off the sidewalk because the sidewalk was crowded. And sometimes they would get off the sidewalk and the officers would tell them to get back on, and they would. The testimony was initially they complied. But as officers quit going along with them and they went out on their own, they went down the street. And then that's when they made the first illegal crossing. Now, in regard to the culpable mental state, I wanted to bring to the court's attention a case that we found after briefing, but I would like to bring to your attention Bailey v. State, 302 Southwest 3rd, 544 out of San Antonio. That's a 2004 case, and in that, the Bailey case stated that obstructing a highway is a conduct-oriented offense, not a result-oriented offense, as they maintain. And that because of that, our mens rea instruction was appropriate. We've shepherdized that. There's no conflicting authority. It's the only case on the books citing what obstructing a highway is. So I would like the court to be aware of that.
But you think it's a result-oriented offense, right?
They say result. Therefore, there should not have been a mens rea instruction as there was.
You're thinking it's conduct.
We say we're not thinking, we're saying it is according to the Bailey case. There's no contradicting authority on that. San Antonio 2004. So I would like to bring that to the court's attention. I would also like to bring to the court's attention regarding their ineffective assistance claim. Trial counsel has had no opportunity
With regard to that,
to respond to these allegations.
is the test still reasonable trial strategy?
As far as I know, it is.
Okay. I understand that normally trial counsel are supposed to be afforded opportunity to say why they did or why they didn't. But as the Court of Criminal Appeals reiterates the test, they include maybe tongue-in-cheek the concept that You give them opportunity to talk unless there's no reasonable trial strategy possible.
Your Honor,
Is
I
that more or
believe
less the test?
I believe the language is that it has to be such outrageous conduct that no rational attorney would have engaged.
Why would a rational attorney allow a juror who said they're guilty on the jury? Give me a reasonable trial strategy.
If you're limiting me to those facts, I would have to agree with you. But that's not what we have here.
What do we
The
have?
two jurors that they complain of that got on the jury, the first one, she made a statement, she said something along the lines, if they hadn't done something wrong, we wouldn't be here. But almost in the same breath, she said, however, I will apply the law, and I will listen to the law and apply the law. So, in my opinion, she possibly could have rehabilitated herself right in that statement. Trial counsel could have been exercising trial strategy. The other one said, at a later time, after she made a statement that sounded like she prejudged guilt, she made a statement that her family had trouble with law enforcement, that her father and brother and a sister, I believe, had trouble with bad experiences with law enforcement. So it's possible counsel at that time was exercising trial
To what
strategy.
extent can we interpret what the juror said? Because, paraphrase what you said, the first one, the comment was, if they were following the law, we wouldn't be here. I'm going to follow the law, which indicates she already decided they weren't following the law, so I'm going to follow the law and convict them. Can we, to what extent can we interpret
Okay.
what the juror meant?
We don't know, here's the problem. We don't know who the most important person that heard that, how they interpreted it. That was trial counsel. We don't know. We don't know what she was thinking because there's no record of it. If she was possibly thinking that, what she means is that she's going to follow the law. And I'm going to, or she felt like someone else was worse than her.
I
She
understand
was
where you're going.
exercising trial
I
strategy.
don't understand where you're going.
So,
Thank you, counsel.
I have one
Yes,
other
ma'am.
quick question. What is your interpretation of the statute 42.03A1, where it says, and whether the obstruction arises from the defendants, and they were listed specifically, I think, defendants' acts alone, or from the acts of the defendant and the acts of others?
well, I think that, to me, that includes that if they participate in the act of others that create an obstruction, it's sort of a party accomplice thing.
Well, is that relevant here?
I don't believe it is from the standpoint that they were clearly identified as participating in this. I don't believe that would be relevant, but if you wanted, you could also go there, you could also show that through the acts of others, you can look at this video, or this picture, and see that it's not reasonable that they didn't actively participate.
But if the case wasn't tried on that basis, it was included because that was part of the statute.
Included in the charge, or included?
Yeah, it was included in the
In
charge.
the court charge, it was included or the act of others?
Mhm.
Isn't that the language of the statute?
It is.
Okay, so that's why it was included
Yeah,
in the
but
charge.
that wasn't your theory.
No, not necessarily, no.
But the
We
jurors-
felt like we proved in direct participation.
The jurors were free to consider that.
I suppose so, but see, the problem with it, there was no objection at charge time. We had no idea it was an issue because trial counsel did not object. And therefore, we believe wait there.
That answered my question.
Thank you, counsel.
Okay? Thank you. Excuse me, let me get my water.
Yes, of course.
Thank you.
first with Chief Justice Quinn, your question about the interpretation of whether unreasonably inconvenient is affected by the First Amendment and the First Amendment standard in particular. And it is. There is greater breathing room that is given to the First Amendment itself. And marching and protesting is core First Amendment protected activity and the foundation of liberty as well in our democracy. It is not unreasonable to stop for a moment in the context of First Amendment activity, and even in the context of non-First Amendment activity, however, we see that the court in Morrison v. State found that subjecting people to prosecution for just momentary stops or rendering some delays on the street would threaten every male person to prosecution under the statute. And we can see that that would also affect trick-or-treaters who are trick-or-treating through their streets as well. But when it comes to the First Amendment and core political marching activity that appellants were engaged in here, there's even more deference to the First Amendment and more breathing room that's given. And this is true again in Sherman v. State.
True or false, exercise of protected rights often impedes, causes disruption?
There's a balancing test, and yes, there could be some inconvenience, but when we look at unreasonably, that will be interpreted in a way that will allow First Amendment activity rather than squash it or completely suffocate it. But to address some of the other issues, I'll address the photo that my opposing counsel is showing. When you look at the photo first, you see that appellants are mid-stride. There are only two of the appellants that are in this photo. The state confused throughout the trial itself and in briefing which elements of the statute were met for which particular appellant and at what particular time. And this is an issue that we see continuously. Here you see marchers moving continuously through the street. There's no obstruction that is visible. There's no car in that photograph that you can see that's approaching behind them as well. And it's on California Street where there's a railroad crossing and cars have to stop at many points throughout as well. And then the state also points to a voice in the video, and I'd like to note for this court that that voice is not tied to any of the appellants. Here, there's no evidence in the record that the voice in the video was appellants' voices. And again,
you're talking about the voice that said they're telling us to get out of the streets, but we don't have to do that.
Exactly.
That was, if you listen to the video, that was someone who came into town, especially for that particular protest, and wasn't involved with the organizers, I guess.
Yes, Your Honor, that is what the evidence shows. And so again, taking this information and trying to use that as mens rea for appellants when it's a completely separate person making claims is just not, it would require inference upon fact that simply is not even there in the record.
Can you quickly address the two jury charge issues you believe you preserved?
Yes, Your Honor. So the first is the inclusion of mens rea instructions for a nature of conduct offense when section 42.03 is results oriented. And there is also harm that is shown through this where the state emphasized the wrong mens rea. Evidence of standard in the closing argument saying that protesters chanting shows an intent to be on the street, but what's needed here is an intent to obstruct, not simply to be on the street. And my opposing counsel pointed to the case Bailey v. State, and I'd like to briefly address that as well. So Bailey v. State, which is not binding on this court, it does not consider the text of the statute itself, which makes clear that obstruction is what's tied to the mens rea, and in fact it specifically says regardless of the means of creating the obstruction, making clear that it's a results-oriented offense. But second, the Court of Criminal Appeals has said that the gravamen of the obstruction statute is obstruction, and so the mens rea standard must apply
Is
there.
that in the Sherman case?
No, that's Bailey.
No.
That will be, I believe, Hay v. State is the Court of Criminal Appeals
Did that
case.
come before or after Bailey?
That came out before, let me just double check. They came out actually the same year, so very in close proximity to.
Which one is the latest?
Which
one would control?
The one that would control, yeah, sorry, Your Honor, the one that would control would be, hey, it's a Court of Criminal Appeals opinion here, so it would control regardless. And so just in closing briefly, the evidence is
Does
insufficient.
that cover both of your questions? We've got both instructions.
There's another instruction as well that was there. I can also
What's the last one?
cover that as well. So the other one that was preserved is an incorrect instruction on the First Amendment defense, in which the jury charge says that it is not a defense to obstructing a highway or passageway that the defendant is involved in a protest or a demonstration. And this is clearly incorrect and also contradicts the following instructions in the jury charge that lay out the language that about the defense that is present in 42.04. And so this caused harm by not allowing the jury to consider a statutory defense or rendering the information so confusing in the jury charges to not be able to consider it.
Thank you.
That wasn't a misstatement of the law, was it?
Your Honor, it directly contradicts a defense that is present in section 42.03, section 42.04, and in addition, it actually, when you look at the case law in Sherman v. State, the Court of Criminal Appeals has found that there must be breathing room given to the First Amendment, so the First Amendment is clearly a consideration, with which the jury was told not to consider here as a defense.
Thank you, Counsel.
Thank you.
The case is submitted, and the attorneys and parties are excused, and want to again thank you for traveling to Amarillo and presenting the arguments. Very interesting case, and we will have our ruling coming forthwith. We will be in recess 5-10 minutes. Stick around.